Hi, welcome back. In this session, we are going to discuss about rules of a trade union. That is, provisions to be contained in the rules of a trade union. So that is discussed in section 6. Every registered trade union is required to have written rules dealing with a certain matter specified in Schedule 2 of the Central Trade Union Regulations 1938. So, that is matters specified in Schedule 2 of the Central Trade Union Regulation 1938. These rules generally determine and govern the relationship between the trade union and its members. So these rules are for relationship between trade union and its members, the members of the trade union. They also provide guidance for the internal administration of the trade union. A trade union shall be entitled to registration under the Act if 1. The executive of the trade union is constituted in accordance with the provisions of the Act. 2. The rules of the trade unions provide the following matters, namely 1. The name of the trade union. 2nd. The whole of the objects for which the trade union has been established. 3rd, the whole of the purpose for which the general funds of the trade union shall be applicable. All of such purpose shall be purposes for which such funds are lawfully applicable under this Act, that is Trade Union Act of 1926. Then the fourth one, the maintenance of a list of members of the trade union and adequate facilities for the inspection thereof by the office bearers and members of the trade union. Then we have the fifth one, that is the admission of ordinary members who shall be persons actually engaged or employed in an industry with which the trade union is connected, and also the admission of the number of honorary or temporary members as office bearers required under section 22 of to form the executive of the trade union. Then we have the sixth one, that is the payment of a subscription by the member of the trade union, which shall not be less than 25 naya paise per month per member. Then we have the seventh one, that is the condition under which any member shall be entitled to any benefit assured by the rules and under which any fine or forfeiture may be imposed on the members. Then the eighth one, the manner in which the rules shall be amended, varied or rescinded. Now the ninth one, the manner in which the members of the executive and other office bearers of the trade union shall be appointed and removed. And the 10th one, the safe custody of the fund of the trade union and annual audit in such manner as may be prescribed of the accounts thereof and adequate facilities for the inspection of the account books by the office bearers and the members of the trade union. And the last one, that is the 11th one, the manner in which the trade union may be dissolved. To summarize, we have 11 points. The first one is the name of the trade union, and the second one is the object of the trade union. Then comes the third one, the purpose for which the funds of the trade union shall be used. The fourth one is relating to the maintenance of a list of members, including that of the office bearers. And the fifth one is regarding the admission, that is with admission of new members, that is with the ordinary members or the honorary members or the temporary members. Now to form an executive, we also admit honorary temporary members, that is discussed in section 22. And then we have the sixth one, that is regarding the subscription of payment of subscription fee. Then the seventh one, that is with the conditions that that governs the that gives the power to the trade union to impose any fine or forfeiture on its members. Then the eighth one is the manner in which these rules shall be amended or varied or rescinded. Then the ninth one we have, that is the manner in which the executive and other office bearers shall be appointed. Then the 10th one we have is the safe custody of the funds of the trade union, and the 11th one is the manner in which this trade union may be dissolved. So these will be the 11 important points or the matters that shall be included within the rules. So if to form a trade union, to register a trade union, we have two requirements. The first one is the executive of the trade union is constituted in accordance with the provisions of the act. So this executive is anyone who has the not by name but by the function they perform a management of all the affairs relating to the trade union. So that was discussed under the definition session. Now the second requirement is there are rules laid down which includes 11 matters. The 11 matters we already discussed, that is the name of the trade union, the object of the trade union, purpose of the fund of the trade union, then the maintenance of list of the members, then the manner in which new members, that is ordinary members or temporary members or honorary members for the executive, may be admitted to the trade union, then the payment of subscription fee, and then we have the conditions in which a member may be imposed with a fine or a forfeiture. Then we have the manner in which these rules may be amended or rescinded or varied. Then we have the manner in which the members or the office bearers are appointed. Then we have who about the custody, safe custody of the funds of the trade union, and then we have how the trade union may be dissolved. So these are the matters that is discussed under the rules. Now we have a case law here, that is IT Commissioner versus West Bengal, IT Commissioner West Bengal versus IS Mills Association. So Indian Sugar Mills Association was a registered trade union. Rule 4 and 64 were repugnant with each other. The rule 64 should be treated as void as it was inconsistent with the stated object of the union. So in the rules set out by the trade union, the rule 4 and 64 was repugnant with each other, and it was ruled that the rule 64 should be treated as void as it was inconsistent with the stated objects of the union. Now, it was held that the court had no right to assume some of the stated objects of the association as primary, to declare others in apparent conflict with them as of no effect. All rules framed by the association coexist. Further, the court had no right to rewrite rules of a trade union by deleting any of them. And there was appeal on this. Okay, so that was what was held in IT Commissioner of West Bengal versus IS Mills Association, where the court had ruled that the rule 64 shall be treated as void as it is not inconsistent with the object of the trade union. But it was further ruled that the court has no jurisdiction to do that. The court has no power to delete any rules of the trade union and add new. Now, regarding appeals, a limited right of appeal from the decision of the registrar is granted by section 11. So here it is a limited right of appeal, and that is discussed in section 11. Any person aggrieved by the refusal of the registrar to register a trade union or by the withdrawal or cancellation of certificate of registration has the right of appeal. The appeal should be preferred within the prescribed period. The proceedings by way of appeal must be started within 60 days of the date on which registrar passed the order against which appeal is made, and that is given by Central Trade Union Regulations 1938 Rule 10. Central Trade Union Regulations 1938 Rule 10. Now, fund of the union. A registered trade union has two funds, namely a general fund and a separate fund for political purposes. So it has two funds, one is general fund and a separate fund for political purposes. Now, object for which general fund may be spent, that is discussed in section 15. The objects for which general fund may be spent is discussed in section 15. Section 15 of the Act specifies the object for which the general fund of the trade union can be utilized. The fund can be utilized only for these purposes. They are mainly, we have 10 purposes. The first one, payment of salaries, allowance and expenses of the office bearers, that is office bearers of the trade union. This is general fund of we are discussing about on which aspect the general fund of the trade union can be utilized. The special fund is for political purpose. So the first one in general that a general fund can be used is to pay the salaries, allowance and expenses of the office bearers. The second one, administrative expenses including audit of the accounts. The third one, the prosecution or defense of any legal proceeding to which the trade union or any member thereof is a party. The fourth one, to conduct of the trade dispute on behalf of the trade union or any member. The fifth one, compensation to the members arising out of trade dispute. Now, sixth one, allowances to members or their dependents on account of death, old age, sickness, accidents, etc. The seventh, payment of policies. Eighth, the provisions of educational, social, and religious benefits for the members or their dependents. The ninth one, to publish a journal or any periodical intended for the promotion and welfare of the class and for discussing questions affecting the employees or workmen as such. And the 10th one, any other object which the government may specify from time to time. Now, it will be illegal to spend the union funds for any purpose other than those stated here. It is illegal to devote union fund in support of an illegal strike or lockout, and the union can be restrained by injunction from applying its fund for any unlawful purpose, because such an expenditure shall be ultra vires of the act. That is the Trade Union Act. Now, Union of General and Municipal Workers versus Gillian, and that is in 1950 case. Here it was ruled by the Supreme Court that payment to workers during an illegal strike from this fund, that is the general fund, is an ultra vires act. Now, Gross versus British Iron, Steel and Hindred Trade Association. Gross versus British Iron, Steel and Hindred Trade Association. Here, a member of the trade union was injured by an accident, the particulars of which were supplied to the secretary of the union. Papers were forwarded by the secretary to the legal advisor of the union. The solicitor was of the opinion that there was no legal cause of action against the employer. The legal advice was communicated to the injured workman and was also accepted by him. But when the period of limitation for claiming damages expired, the member brought an action against the union for failure to exercise proper care and diligence in pursuing his claim. It was held that the union was not liable. The court, pointing out the duties of the trade union towards the member, observed that if the solicitor of the union had advised that further inquiries should be made or that an action should be brought, the union would have been under a duty to act accordingly. But in the absence of any such direction from the solicitor, the union had fulfilled its duty by providing legal assistance which was adverse to claim. So that was ruled in Gross versus British Iron, Steel and Hindred Trade Association. Then the general fund we were discussed in section 15, and now political fund is in section 16. A registered trade union can constitute a separate fund called political fund. If the registered trade union decides to carry out political objectives, it has the authority to constitute a separate political fund for such activities. Thus, the political fund is a fund constituted separately by the trade union by way of separate contribution collected from the members for the promotion of civil and political interests of the members of the trade union. The fund can be used for the following subjects. So, with respect to general fund, we discussed 10 scenarios or circumstances where the general fund can be used, and with respect to political fund, we are going to discuss about 5 circumstances. That is, for the payment of any expense by a candidate for an election in assembly, parliament, local body, panchayat or municipality. The second one, the holding of any meeting or distribution of any literature or the documents in support of such candidate. The third, maintenance of any person who is a member of any legislative body constituted under the constitution or of any local authority. The fourth one, registration of electors or the selection of a candidate for any legislative body. Now, the fifth one, the holding of political meeting of any kind or the distribution of political literature or political documents of any kind. So, these are the 5 circumstances where the political fund is used. Once again, for the payment of expense by a candidate for an election, that may be in assembly, parliament, local body, panchayat or municipality. So, expense by a candidate for an election. Then the second one is for holding meeting or distribution of any literature or such expense. Then the third one is maintenance of a person who is a member of any legislative body constituted under the constitution of any local authority. Then the fourth one, registration of electors or the selection of candidate for legislative body. Then the fifth one, the holding of political meeting of any kind, or the distribution of political literature or political documents of any kind. Thus, all the necessary and proper steps may be taken by the trade union for the promotion of civil and political interest of its members. It may take all steps for the canvassing of the candidate and allied matters. The contribution to the political fund is voluntary and there can be no compulsion in this regard. The mere fact that a particular member failed to pay a political fund does not disentitle him to claim benefit. In other words, there is no discrimination against that member. It may be pointed out that no member can be expelled from the membership of the trade union on the ground that he has refused to contribute to the political fund. Now, continuance of trade union membership beyond cessation of employment. So, in Bokhajan Cement Corporation Employees Union versus Cement Corporation of India Limited. Bokhajan Cement Corporation Employees Union versus Cement Corporation of India Limited. That is a 2004 case. Here, the Supreme Court held that there is no provision in the Trade Union Act providing for automatic cessation of a trade union membership on cessation of employment. So, there is continuance of trade union membership beyond cessation of employment. The court observed that the section 6 subclause E does not provide that on cessation of employment an employee would cease to be a member of the trade union. The court declared that an employee on ceasing to be employed does not lose his right to continue as member of the trade union unless the constitution of the union otherwise provides. So that depends on the constitution of the union, that is the rules based on it. So the rules of trade union is discussed in section 6 and we discussed about the funds that the trade union has, that is section 15 with respect to general fund and section 16 with respect to political fund. We discussed about 10 circumstances where general fund can be used and 5 circumstances where political fund can be used. So that is with this session regarding rules of trade union under section 6. Thank you for listening. Like, comment and subscribe. Don't forget to click that bell icon so that you get an update when I upload my next video or a podcast. Thank you.